I want to address 5 keys, I would call them, to memo writing that you don't often hear. These are things that we should be talking about and that we should be training you on, but they're not always part of the conversation when we're talking about legal memos. Hi there, I'm Paula Clammer. I'm a lawyer, translator, and legal English coach who has spent the past 20 years working at the intersection between law and language, helping high-performing professionals to really hone their language skills and to communicate effectively in English as a second or foreign language. And one of the things that my students often have to write are legal memos. And so I have a lot of recurring questions that come up that my students have asked me throughout the years about memo writing. And what I did was I put together several different resources to help you to be able to write really good legal memos. And so in this video in particular, I want to address 5 keys, I would call them, to memo writing that you don't often hear. These are things that we should be talking about and that we should be training you on, but they're not always part of the conversation when we're talking about legal memos. And some of them may be a little obvious, but if they were that obvious, then they would be part of the conversation. Here they are. Chronological order isn't everything. And you might be thinking, what is she trying to say? What does that even mean? Chronological order isn't everything. Usually when we teach people how to write legal memos, we tend to tell people to write out, especially the facts, in chronological order so that it's reader friendly, so that the reader can really understand what the facts are and then later follow you in the discussion section of your memo and really be able to understand how those facts relate to the rule when you're actually addressing that directly. Now, a lot of times chronological order isn't the best order for us to actually be able to tell the facts in the form of a story that later fits the rule that we will analyze as part of our rule-based reasoning process in the discussion section. And so sometimes it actually makes more sense to tell things in a sequential order. But my point here is that it's important to remember that while putting things in chronological order does of course make sense, it is very logical and it is overall a good rule for us to follow, chronological order isn't the only order that we can put things in to make them truly effective and reader friendly. And so sometimes sequential or consecutive order are going to be more appropriate. Memo writing is intended to be predictive, not argumentative. And again, you might be thinking, what is she talking about? If you are doing an LLM in the US, a lot of your professors are asking you to write something that they're calling legal memos, but where you're required to actually put forward an argument. Or if you work in the international public law arena, for example, if you work in human rights law, you might be producing for certain organizations papers or research in a format that is referred to internally as a legal memo, but it is in fact argumentative. So what I want you to really think about here is that those are exceptions to the general rule. The general rule is that legal memos throughout the wider portion of global law practice are really not intended to be argumentative at all. They're intended to be predictive. The client has asked a question and we want to be able to answer that question. So really what the client is expecting from us is a legal analysis that will help them make a decision. not all memos are client facing. And I know that that seems to kind of contradict what I just said, but think of it this way. Sometimes we write our legal memos, and those legal memos are really never going to make it to the client's hands. Sometimes we're writing our legal memo for a partner at our law firm, and it's the partner at the law firm who's going to communicate the content of that analysis to the client. And so the reader is not the client, but that doesn't make our purpose of that memo any less predictive than if it were directly client facing. So what changes? What changes if our memo is client facing or not is going to be our communicational style. It's going to be whether or not we can use terms of art. Or we can always use terms of art, but it's not always recommended. If something is client facing, it's always a better idea to say things in plain language. Whereas when we're talking expert to expert, we can allow ourselves to use certain terminology that's more advanced. We can be a little more detailed into the nitty-gritty of the law so that the other expert can really wrap their head around the concept. There are things that we don't need to explain when we're writing expert to expert that we would need to explain explicitly if the document were client facing. And so really what I'm talking about here is that we need to remember who the reader is, and it's not always going to be a client, but we do need to adapt our style, our tone, and the way we go about presenting information to that reader. We do not write the same way for a fellow law expert as we would for a reader who is a layperson. Just because you're writing in English, that doesn't mean that your reader is a native English speaker. And the reason why I think that's important is because I want to take a little pressure off of you. One of the things that people who speak English as a second or foreign language often worry about a lot is, am I saying this the way a native speaker would say it? Personally, I don't think that's the correct standard to use in any kind of writing. There is no reason why the native speaker standard should be the standard by which you, as someone who learned English as a second or foreign language, measure your own proficiency. You can be an incredibly proficient, excellent communicator in English and not sound like a native speaker or not write like a native speaker. And that's fine. You're still excellent and you're still proficient in that second or foreign language that you're speaking. So a better standard to measure ourselves with is the effectiveness standard. Is your memo effective? Meaning, can your reader really understand that memo? If you have to explain a complex legal concept, did it come out clearly enough for the reader to understand the concept itself, but more importantly, was it clearly enough so that they could not only understand the concept, but also understand how the concept relates to their question that they asked you? And that is really where most communication breaks down in legal memo writing in a foreign language. It's a lot of information gets lost in assuming that the reader knows things, assuming that the reader has the same level of comprehension as we do as law experts, and that's not always the case. And so that is why this point is so important. So many excellent resources and so many excellent courses part from the presumption that just because you have to communicate in English, you have to learn how to do common law analysis. And that may not be your reality at all. You're only going to do common law analysis if you're going to be practicing law in a common law world. Well, then it makes sense to associate memo writing and the kind of analysis that we do in memo writing to common law analysis. But that only represents a very small portion of what goes on globally in English in global law practice. In fact, the majority of what is actually produced is produced outside of the English-speaking world, outside of common law jurisdictions, and it's still produced in English simply because English is the lingua franca of the law. But many times what you have is civil law analysis. You might be a German professional who is writing for somebody in France or in China, which are civil law jurisdictions. And so you're not going to be doing common law analysis in that case. And there's no point for you to learn only how to write legal memos with common law analysis. You need to be able to write legal memos with civil law analysis, but to do that in English in a way that is effective in terms of how you're communicating the information that needs to be in your memo. And so just to recap what these 5 little tips that I just gave you are: number 1, chronological order isn't everything. Sometimes sequential order or consecutive order can make a little bit more sense depending on your context and what you're trying to communicate. Number 2, memos are predictive. Just because there are exceptions where you might find yourself having to write a legal memo that is more argumentative, as a genre, memos are intended to be predictive. Number 3, not all memos are client-facing, and so you really need to understand who the reader is so that you can adapt your writing style to that reader. Number 4, just because you're writing in English doesn't mean you're writing for native speakers, so you can put some of that pressure off of yourself. You can communicate, just focus on communicating effectively and just being very clear about what it is that you're trying to say. And number 5, just because you're writing in English also doesn't mean that you're doing common law analysis. And so when you're reading, when you're taking your courses, when you're listening to people talk about memo writing, that I want you to have that clear distinction in mind and really think about, well, what does my practice require of me? And how much of what is being presented to me in this book or in this resource or in this course or wherever is actually applicable to my reality? If you would like to learn more about legal memos, I did put together a free PDF that you can download from my webpage directly. In that PDF, I cover what legal memos are. I cover where people generally go wrong when they're writing legal memos in English. And I give you a 5-step framework for really being very effective in your memo writing process. Thank you for watching this video. I hope that you enjoyed it. If you did, I hope you give me a little thumbs up, leave a comment. I always find those very encouraging. Share it with other people if you found it helpful, and subscribe to this channel so that every time I publish something, you will know.